right. So let's go to the Supreme Court. Let me share this. I'm a raise up your blood pressure in a minute. Okay. So the Supreme Court on this morning, signaled that it was likely to strike down a federal law that restricts the president's ability to fire members of the Federal Trade Commission. During 2.5 hours of arguments in the case of Trump versus Slaughter, a solid majority of the justices appeared to agree with Trump administration that a law prohibiting the president from firing FTC commissioners, except in cases of insufficiency, neglect of duty, or malfeasance in office,
that means you did wrong.
Violates the constitutional separation of powers between the three branches of government. And although several justices expressed skepticism about a 90-year-old case, Humphrey's Executor versus United States, upholding that law, it was less clear that there was a majority ready to overrule it.
Well, I don't have any problems with this. See, part of what the law is about is things happen. There's human progress or regress. And sometimes what goes on is circumstances develop that were not anticipated by the people that wrote the Constitution. Couldn't have. Like, for example, there is a whole large body of law that impugns on the concept of piracy, and it involves airplanes. In 1789, when the Constitution was adopted, who had ever fantasized about an airplane? And people commonly traveling in airplanes rather than ships. So, these things change and the law must change. And by the way, the very first case said the common law of the United States, which is the fundamental law until it is overturned or modified by statutory law, is, quote, this is a quote, that body of judge-made law based on tradition, precedent, and the evolving conditions of society, unquote. That is a case all the way back from 1792. So that's about as old as it gets. And it is case number 1, volume 1, page 1 of the reporters or the volumes of law reports that recite what the Supreme Court has done. So, yeah, it changes.
Well, I want to play a couple of snippets from the justices' remarks of today's hearing.
Some issues, some matters, some areas should be handled in this way by nonpartisan experts. That Congress is saying that expertise matters with respect to aspects of the economy and transportation and the various independent agencies that we have. So having a president come in and fire all the scientists and the doctors and the economists and the PhDs and replacing them with loyalists and people who don't know anything is actually not in the best interest of the citizens of the United States. These issues should not be in presidential control. So can you speak to me about the danger of allowing in these various areas the president to actually control the Transportation Board and potentially the Federal Reserve and all these other independent agencies? In these particular areas, we would like to have independence. We don't want the president controlling. I guess what I don't understand from your overarching argument is why that determination of Congress, which makes perfect sense given its duty to protect the people of the United States, why that is subjugated to a concern about the president not being able to control everything. I mean, I appreciate there's a conflict between the two, but one would think under our constitutional design, given the history of the monarchy and the concerns that the framers had about a president controlling everything, that in the clash between those two, Congress's view that we should be able to have independence with respect to certain issues should take precedence.
Well, first thing I'd say in response to that is I've been dealing with law longer than she has, went to a comparable law school, and my legal career was as good as hers, so I can speak. But I would also say I think she represents the concept she's speaking against. We've got an idiot, Joe Biden, who nominated her for president, and he passed on the Second Circuit Justice Roger E.
He
Clifton,
nominated her
who is a
not
fine
president.
black woman. What's that?
Justice, not president. You said nominated her.
No, I'm saying President Biden. Illustrating her point, she got nominated by an incompetent idiot. And if we took her line of argument, we would say he should not be allowed to make nominations, even though the Constitution says he can. And we would have said, why didn't we nominate Justice Roger E. Clifton from the Second Circuit or Justice Bernice Donald from the Sixth Circuit for the U.S. Supreme Court? Both fine black women that I'm personally acquainted with, know their husbands, great people, brilliant scholars, and actually have been in the trenches dealing with the hands-on face-to-face type law that deals with most humans in America. The whole thing that she's putting out there says that the Congress of the United States has set up a situation with the Fed and some other things because their ignorance and their inability to conceive of, understand, and manipulate economics requires that you get these independent experts who are put in a position not by the vote of any body of people, but by their representatives. And what happens is that they control the lives, the economics, the finances, and the well-being of so many American citizens, and nobody voted on them. Now, what is going on that makes her argument absolutely crap is the fact that the president under the Constitution is responsible for all of this. These individuals are part of the executive branch of the government. He is the person responsible for them. And to tell him, we put you on a situation where we're going to hold it your fault. And as Truman famously said, the buck stops here. And he pointed at his White House desk when he was sitting behind it in the Oval Office. He said, the buck stops here. And if the buck stops here, then you have to be given a responsibility to have something to say. Mm-hmm. Well, to have something to say about who you're going to be responsible for. See, the president's not responsible for what the elected officials in Congress do. Yeah, he's not responsible except for those he nominates and gets confirmed who sit on the Supreme Court. So why does he have to be responsible for what somebody that he didn't put in place is going to stick him to?
Well, it says here that is really about, should he have the right to fire experts that are helping to...
Who says they're experts?
No. Okay. So
see, that's the issue. We, the United States of America, have a chief executive. He's known as the president of the United States.
For clarity, because it says a decision in favor of the Trump administration will signify increase the president's power over not only the FTC, but roughly 24 other multi-member agencies that Congress intended to be independent. President Donald Trump has also fired members of the National Labor Relations Board, the Merit Systems Protection Board, and the Consumer Products Safety Commission. The Supreme Court has already allowed those firings to take effect in proceedings on its interim docket. But the court's ruling in the case of FTC Commissioner Rebecca Slaughter will provide a more definitive ruling on the legality of those firings. So basically, they're the
experts. What gives him the authority to fire a so-called expert? Well, who said the person is an expert? The person is an expert. some other president, so you have no longer retained your office. That makes you a better authority on who's expert than the current occupant or her. That was my point for the original dialogue. Who says she is the expert on American law that ought to be sitting on the highest court of the land? I'd say in her own circumstances, there are at least two people I'm personally acquainted for that would be more qualified and a better expert. And I don't acknowledge her expertise. I not acknowledge and respect her
Let me
office.
say this. It's not, let's move from her for a second, because it says the FTC has 5 commissioners who are appointed by the president and confirmed by the Senate to serve 7-year terms. Under the law governing the FTC, no more than 3 of the commissioners can come from a single political party. And as noted above, commissioners can only be removed from office for inefficiencies, neglect of duty, and malfeasance in office.
Look at our lousy economy that we inherited from the Biden administration that the first Trump administration couldn't overcome after that clown Barack Obama did what he did with his cronies and his Indonesian trust fund that profited so much from the circumstances he helped create. Look at his relationship to his cousins, George Herbert Walker Bush, George Walker Bush, Dick Cheney, Governor Palin of Alaska. Look at those people and look at Uncle Herbert Walker, and you see the cabal that was dealing with a certain economic perspective. Look at what happened with Gulf War I, where the Bush family's fortune was wiped out because Hussein nationalized, amongst other entities, Zapata Offshore Oil Inc., which was the Bush family holding company. Look at what happened when Halliburton, which is started by Uncle Herbie, the Bush Walker family business that got the huge contract without bid to exploit Iraqi oil in 2007, that as of 2008 was returning $2.4 to $2.7 million in profit every 7 hours of the day to them.
I want to play.
These things are what we get stuck with. What my point is this: who says that these people are the best experts you can find? What about the experts who are supposed to be that, who tell you about what the Rainbow Coalition is pushing being normative? It's not.
All right.
And they are a very distinct minority, yet some people, the press and all of that, want you to believe that they're experts.
All right, let me play this clip here.
Some issues, some matters, some areas should be handled in this way by nonpartisan experts. That Congress is saying that expertise matters with respect to aspects of the economy and transportation and the various independent agencies that we have. So having a president come in and fire all the scientists and the doctors and the...
I think I played that one.
Yeah, you did. And that point still belabors the point of who says they are the best experts in the subject, or not just somebody who happens to, irrespective of their party, display a certain ideological leaning.
This morning in case 25332, Trump versus Slaughter. General Sauer.
Mr. Chief Justice, and may it please the court. In SELA law, this court held that the president's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2, was settled by the first Congress, and has been confirmed by precedent, including at least 9 decisions of this court from Ex parte Hennon through Trump against United States. Humphrey's executor stands as an indefensible outlier from that line of authority. It's holding that federal agencies can exercise quasi-legislative and quasi-judicial powers that form no part of the executive power has not withstood the test of time. That holding was gutted and refurbished in Morrison, but this court correctly rejected the refurbished version as providing an amorphous test with no limiting principle. Respondent now proposes a third update to Humphreys, which this court has already rejected as making no logical or constitutional sense. Humphreys must be overruled. It has become a decaying husk with bold and particularly dangerous pretensions. It was grievously wrong when decided, and cases from Morrison to Trump have thoroughly eroded its foundations. The court has repudiated Humphrey's reasoning and confined it to its facts, but it continues to generate confusion in the lower courts, and it continues to tempt Congress to erect, at the heart of our government, a headless fourth branch, insulated from political accountability and democratic control. As Justice Thomas wrote in Selah Law, Humphreys poses a direct threat to our constitutional structure and, as a result, the liberty of the American people. And as Selah Law held, the modern expansion of the federal bureaucracy sharpens the court's duty to ensure that the executive branch is overseen by a president accountable to the people. I welcome the court's questions.
General Sauer, could you give us one example of a permissible restriction on the authority to remove a principal officer?
We don't believe there are permissible restrictions on principal officers of the United States who exercise the executive power. Now, there may be separate issues relating to
let's say
particular historical pedigrees.
In this case, in a multi-body agency such as the FTC, is there any permissible restriction?
No, this court in Trump against the United States held that the president's power to remove officers wielding the executive power is conclusive and preclusive.
How far do you go with that? Can it be arbitrary, completely arbitrary?
It is conclusive and preclusive, so any review of arguably bad reasons for the president to remove an executive officer would be subject to the political process. It would not be subject to judicial review, and certainly not subject to statutes regulating that.
Well, let me put it this way. When I had it explained to me 55 years ago in law school, what it is this. Think of a general. A general cannot be appointed to command authority without the consent of Congress, but he can be removed by the commander-in-chief immediately, since the commander-in-chief has the ultimate authority and is ultimately responsible. That is the same thing that applies to these appointed offices. He cannot appoint somebody to exercise this authority that is implicit in the position being appointed without the consent of Congress. They have to approve it. But that is not to say that he cannot remove somebody because that person is, say, totally against what the people elected him to do. Let's say we go back to the 1930s. We are in the worst depression in the country's history, the worst in world history, the Great Depression of 1929. And you want to say, well, the president who got elected on a mandate to do something about this horrible economic situation, he can't do anything about it because somebody that was in office several years before appointed somebody who's not subject to any kind of constraints or controls whatsoever. That's not going to be. And in this case, there's only one segment of government where that is allowed. It's the courts themselves on the federal level, where they maintain a lifetime appointment for life or good behavior. In other words, the good behavior is said as long as you don't commit a crime in office, you're okay. Nobody can touch you because we want independence for our judiciary. But other than that constitutional mandate and requirement, there's nothing in that Constitution that says, hey, you get stuck with something some bureaucrat did some time ago and there's no way of going behind it. You have to logically give the president the authority to remove someone who is exercising inappropriate judgment and making bad calls on what he's supposed to be directing. You have to. And that's what these decisions said. Inherent in the power that the president has as the chief executive over the executive branch is to manage and direct the executive branch, and he has the authority to remove those who are supposed to be executing his authority on his behalf if they're not doing so.
Right. Well, I want to play this clip of Justice Sotomayor.
She's going to be on the other side, I know.
Severability of the issue. Meaning, if you think they're wielding power that is inappropriate, why don't we sever that power
I think those very arguments,
instead of the removal power?
well, for example, consider an agency like the FTC, which is before the court. Virtually all of its powers, I can't think of a power that exercises this.
But most of those powers were part of Humphrey's. This court, even in Sheila Law, and all of the cases you've mentioned since, have said that Humphrey's is controlling law. You're asking us to overturn a case that has been around for nearly 100 years, correct?
90 years, I believe.
90 years. What other cases have we overturned that have had a pedigree of 100 years?
Plessy
Neuer
versus
against Neff
Ferguson.
was overruled by Schaefer against Heitner on its 100th birthday.
That was
so
an
to speak.
economic case. What other case?
For example, Erie overruled a 50 Tyson 96 years later. Those
That's
are two
absolutely
examples. There's at
true.
least
Again,
13 or
but which other case has fundamentally altered the structure of government?
Brown
For
v.
over
Board of
100 years.
Education.
Actually, since 1887, we've had multi-member boards, and that's the entire government structure.
the distortion of the structure of government, respectfully, that Humphrey, the philosophy of Humphrey's,
Aren't you asking us to distort it a different way?
I think we're
Neither
asking,
the king, nor parliament, nor prime ministers, England at the time of the founding, ever had a unqualified removal power. You're asking us to say that at a time, the founding, when the Constitution doesn't speak about this at all, where there was robust debate over this issue among legal scholars at the time, that we ourselves has said repeatedly in Humphrey's and other cases, Wiener, even in Myers, that that those cases you mentioned did not establish this absolute power of the president. You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
I think we're asking the court to return to the dominant line of authority that started in Ex parte Henin in 1839, when this court said that it's a settled and well understood construction of the Constitution. The president alone can remove executive officials. That was reaffirmed in Parsons, for example, where it described it as settled beyond the power of alteration. Again, in Shurtleff, similar language. Myers says the same thing. Free Enterprise Fund, Collins, Seal of Law, Trump against the United States, and even Humphrey's executor itself paid lip service to this principle. Humphreys described this power as unrestricted and illimitable. And in order to get out of that rule, which the court has recognized in those 9 decisions, is going back
You
to
still haven't
1789.
answered my question.
He just answered it, lady.
Where else have we so fundamentally altered the structure of government?
I think what the fundamental alteration of the structure of the government was ushered in by Humphreys, and then the Congress kind of took Humphreys and ran with it in the building of the monastery administrative state and the proliferation of independent agencies that are insulated from
Independent
democratic
agencies
control.
have been around since the founding, the Sinking Fund, the War Commission. We've had independent agencies throughout our history. So this is not a modern contrivance.
We disagree with that, as in our brief, we disagree with that characterization of those agencies. The Sinking Fund Commission, for example, was composed of 3 officers who were cabinet
And we have an
secretaries,
amicus that
clearly
shows
removable.
us how the president's
Well,
will
lady,
have been
could you let him
thwarted
finish
by
his
that
point?
structure.
Come on.
We have an amicus brief that shows us how that the president's will
stop this for a
by that
second?
structure.
She's illustrating the point without realizing it. First off, Brown v. Board of Education upset several hundred years of American history, saying that black folk could be either enslaved or treated as second-class citizens. She also does not deal with the fact that there was a specific case called Plessy versus Ferguson that established separate but equal that Brown v. Board of Education threw out. She's not dealing with the fact that we have the Dred Scott decision that helped start the Civil War that was a decision. And we are forgetting, she's forgetting why she has the authority to hear this case in the first place. It's called Marbury versus Madison, 1803, 222 years ago. The United States Supreme Court upheld the proposition by President Madison, rather, that says when an act of Congress is unconstitutional, the president does not have to follow it. So what happens is Trump is saying this provision of the statutory scheme that is 90 some years old is unconstitutional. It needs to be revised, and he's acting effectively on the plaintiff's side in this case. Really, they are defending and saying, no, what's going wrong is this is dead wrong. This is anti-constitutional. This is inappropriate under the scheme of the American Constitution to say that these appointed officials have more authority about managing the economy than the president's office. Or what are we going to do if some Congress makes a bad approval and ratifies another president's previous selections, and that dead hand is to reach out of the grave and control the activity of somebody who was recipient of a large mandate specifically to reverse some of the policies of the administration that appointed these people.
Right.
The case is Marbury versus Madison, 1803, United States Supreme Court, 222 years old.
Well,
So yeah, and
she's saying that she thinks that you're going to destroy the structure of government.
of course, they think big government is what has to happen, and the people have no choice, and government's supposed to play big brother or tranny big sister and run everything for all of the people in the country. That's what Trump was elected to see to, which is to turn that around.
Right.
So that's what he's doing. And she's going to overthrow the political process by a recently selected elected official.
These kinds of historical examples, I think, have been considered in this court's cases from Free Enterprise Fund and Seal Law and so forth.
So what do we do
There's been a lively
with
debate
Morrison?
about that, and the court
What do we
has
do with Morrison and Weiner and Perkins?
Well, Morrison, for example, I think is a really critical precedent here, because what Morrison did is it repudiated the entire logic that supported the holding of Humphrey's executor. It repudiated correctly the idea that there are these quasi-judicial and quasi-legislative powers that are outside the executive power, and yet they're wandering around the executive branch.
You answered the Chief Justice by saying that maybe we just need to look at each agency individually. So we can't leave that area. By the way, your logic, you're putting at risk. By this, you're saying there's uncertainty. I think the uncertainty in the lower courts was not over Humphrey's executor. It has been over the court's most recent decisions, not because of Humphrey's executor. But you're putting at risk the independence of the tax court, of the federal claims court, Article I courts. You're putting at risk the civil service. I don't see how your logic could be limited.
As to the non-Article III courts, we haven't challenged the removal restriction as
Not yet.
non-Article III court in this
Not
case.
yet. Not yet.
And we recognize that there are some line-drawing issues as to those that came up in cases like Freitag and Ortiz. Again, those aren't presented here. Those aren't briefed here.
Not yet.
There's a difference.
This is how.
See, look, what's going on here is she's talking over the man, and if she gave him the 2 or 3 or 4 minutes he needs to make his point, it becomes clear. What is going on is you're talking about appointments to courts, And the Constitution is clear on that. It wants to maintain the independence of the judiciary. The legislative process is not supposed to be independent, but is supposed to be responsive to the people. The House of Representatives, which is elected to 2-year terms, is supposed to be corresponding to the Roman House of Plebes, which deals with the sentiments and passions of the mob on a regular basis. The Senate, which has a 6-year term, is supposed to be reserved and laid back. And as there was this famous exchange between Jefferson and someone else while they were debating these things, why do you pour your tea into the saucer? To cool it so I can drink it. He said, well, that's why we need the Senate rather than just one unicameral or one house legislative body to cool it off. So what she's confusing is a classic situation that comes up when you're trying to teach a lot of first-year students, law students, about congressional law. They get all caught up in the wants and they can't see the forest for the trees. And that's what she's illustrating, which is showing the deficiency of the appointments that the Obama administration is responsible for, that the Clinton administration is responsible for in making the judiciary what it is today. It's not what it ought to be because there are too many people involved in this process who are vested in an emotive or propagandistic or agenda-driven resolution to everything rather than dealing with there is a moderating impact when the law is consistent in its application. And when you have a constitutional scheme that says we have these 3 branches of government, so no one branch can become all powerful, but they can do what they're supposed to do. Well, these appointed officials who hold these 7-year terms act for the executive branch, but it is ridiculous to say you got elected as president, you got a mandate from the people of the United States of America to do what you were claiming you were going to do with your campaign plank, but once you get in, you can't touch it because you were locked into whatever these people who were selected by no democratic process and were put in place by someone who put them in just before you took office, so they're going to have 6.5 years where there's no way to touch them. It's not going to happen.
So the decision for this case is expected in late June or early July of next year.
Next year. Yeah.
Yes.
That's the way things work in America. And also, here's the other thing, too. There have been many points that are not clear with the current status of the law. So they must be brought and decided by various courts.